Judgment in the appeal, the Queen and O'Brien.
Lord Toulson will summarise the effect of the judgment of the court.
It is part of our extradition law that a person who is extradited to the UK for trial on criminal charges cannot be prosecuted for other alleged offences committed prior to his extradition, but for which he has not been extradited. The rule is known for some reason as the specialty principle, and it is laid down in Section 151A of the Extradition Act 2003. There are some exceptions, but we're not concerned with them in this case. The question before the court is whether this rule applies as a barrier to proceedings for contempt of court, where the person concerned had willfully disobeyed a court order prior to his extradition and had then been extradited to face trial in this country for other matters. The question arises in this way. In 2009, the appellant, Mr. Brown, came under investigation on suspicion of involvement in a large-scale scheme to defraud investors of the kind commonly known as a boiler room fraud. On the 24th September 2009, at the Old Bailey, the Common Serjeant made a restraint order against him under Section 41 of the Proceeds of Crime Act 2002. The order required him to make disclosure of his assets, not to remove his assets from England and Wales, and to return within 21 days any movable assets in which he had an interest outside England and Wales. Mr. Brown disobeyed the order and fled to the United States. On the 18th of December 2009, the judge found that he was in contempt and issued a bench warrant for his arrest. Mr. Brown was traced to Chicago. The Serious Fraud Office sought his extradition to face charges relating to the boiler room fraud. He consented to his extradition and an extradition order was made. There was some concern that the outstanding bench warrant for his contempt could complicate the extradition, and so the SFO applied to the judge to set aside the bench warrant prior to his extradition, which the judge did. Mr. Brown was returned to the UK on the 2nd December 2010. He was arrested, charged with various offences and remanded in custody. The SFO then reapplied to the judge for his committal for contempt. Mr. Brown challenged the court's jurisdiction to hear the application. That challenge was rejected by the judge and by the Court of Appeal. He now appeals to this court on two grounds. First, Section 151 of the Extradition Act refers to, quote, an offence committed before the person's extradition. It's argued that this includes any conduct for which he may be punished. It need not be a crime in the strict sense. His contempt was an offence in the broader sense, in that he was liable to be sent to prison for it. If the first argument fails, the alternative argument is that his contempt of court was in any event a criminal contempt and thus constituted a criminal offence, so as to fall within the specialty rule. As to the first point, it is clear from the language and structure of the Act and the legislative history that when the Act speaks an offence, it means a criminal offence. In the judgment handed down by the court today, the reasons for that conclusion are set out in greater detail. As to the second point, in English law, contempt may be classified either as a civil contempt or a criminal contempt. The flaw in the appellant's argument is to suppose that a contempt of a criminal court is therefore a criminal contempt. A person who willfully breaks a court order is liable to be treated as being in contempt of court and punished, but that is not part of our criminal law. It has developed as part of the inherent jurisdiction of senior courts, including Crown Court, to enforce their orders. A criminal contempt is something different. It's conduct which goes beyond mere compliance with a court order and involves a serious interference with the administration of justice. Examples include physically interfering with the course of a trial, threatening witnesses, or publishing material likely to prejudice a fair trial. The question whether a contempt is a criminal court, therefore, does not depend on the nature of the court to which the contempt was displayed. It depends on the nature of the conduct. In this case, the disobedience of Mr. Jones was not itself a crime, and therefore the specialty rule was no bar to the court dealing with him for his contempt. The court unanimously agrees that both grounds of appeal fail and the appeal is dismissed.
Court is now adjourned.